Welcome to my YouTube channel. Today also I am going to dictate dictations on legal matters at the speed of 100 words per minute. Please note down the first one. Ready, start. Leave granted. This appeal by special leave arises from the order dated 21st June 2006 passed by the High Court of Uttaranchal in criminal miscellaneous application number 434 of 2006. By the impugned order, the High Court has dismissed the petition preferred by the appellant under Section 482 of the Code of Criminal Procedure 1973 within bracket for short the code, seeking quashing of the charge sheet dated 16th December 2005 and consequent proceedings initiated against him by respondent number 2 in this appeal, hereinafter referred to as the complainant, for allegedly committing offences punishable under sections 420, 467, 468 and 471 of the Indian Penal Code 1860. The appellant owns a poultry farm. According to the appellant, he used to supply chickens to the complainant and his partner on cash and credit basis. On 15th June 2005, the complainant is stated to have issued a check in the sum of rupees 8,65,000 drawn on Union Bank of India in favor of the appellant against the balance payment due. When the check was presented for payment, it was returned unpaid by the bank with the remarks single inverted comma having no fund single inverted comma close. Thereupon, on 7th September 2005, the appellant served a legal notice on the complainant and his partner in terms of Section 138 of the Negotiable Instruments Act 1881 within bracket for short single inverted comma the act single inverted comma close bracket close, calling upon them to make payment against the said check. On getting the said notice, the complainant is stated to have cooked up a story that he had issued blank checks bearing his signatures to one Salim Ali as security for rupees 30,000 borrowed by him along with a guarantee receipt dated 25th June 2005 on a stamp paper. Salim Ali misplaced the aforementioned blank check, which was fraudulently used by the appellant by filling up the amount of rupees 8,65,000 and was presented to the banker for encashment. The complainant claims to have informed the bank about the loss of the check. On 15th September 2005, the complainant lodged a complaint against the appellant before the judicial magistrate, alleging commission of offences under sections 420, 467, 468 and 471 IPC. The learned magistrate, by his order dated 19th September 2005, directed the police to register the case and investigate it. In the meanwhile, on 10th October 2005, the appellant filed a complaint against the complainant and his partner under Section 138 of the Act and Section 420 IPC. The judicial magistrate took cognizance of the complaint and issued summons against the complainant. Aggrieved by the filing of the complaint by the complainant, the appellant moved the High Court for quashing of the proceedings before the magistrate. As noted above, the High Court declined to interfere in the matter. The prosecution has collected the evidence in this matter, though the evidence has not been filed before this court by the applicant. Non-presentation of statements recorded under section 161 CRPC leads me to take an assumption that the prosecution has led the evidence to support to the contention of the complainant in the present case. This was the first dictation. Now I am going to dictate the second dictation on the legal matter at the speed of 100 words per minute. Please note down. Ready? Start. If there is an evidence and it discloses the prima facie case against the present applicant, there is no requirement of the said statement at this stage. If the applicant wants to make any such averment or submission that it cannot be believed on account of certain contradictions in the documents, it can only be raised during the trial. This court cannot evaluate the disputed facts of the case. This court cannot decide as to whether the evidence is reliable or not. Mr. Salman Khurshid, learned senior counsel, appearing on behalf of the appellant, submitted before us that the order passed by the High Court dismissing the petition is unsustainable both in law as also on facts of the case. It was contended that the High Court failed to appreciate that the magistrate had decided to proceed with the case improperly without application of mind, which is evident from the fact that within bracket 1, the report submitted by the police pursuant to the direction issued by the magistrate under section 156 within bracket 3 of the code was in favor of the appellant. Within bracket second, the check in question was neither seen nor seized by the investigating officer, and within bracket third, the charge sheet filed is perfunctory inasmuch as the assertions made therein, even if taken on face value, do not satisfy the ingredients of any of the offences alleged to have been committed by the appellant. It was urged that the complaint against the appellant was frivolous and had been instituted with an ulterior motive to wreak vengeance and to preempt the filing of complaint against the complainant under section 138 of the Act. It was thus argued that parameters of its jurisdiction under section 482 of the code laid down by this court in state of Haryana and others versus Bhajan Lal and others are clearly attracted on facts in hand, and therefore it was a fit case where the High Court ought to have exercised its jurisdiction under the said provision. Per contra, Miss Anagha S. Desal, learned counsel appearing on behalf of the complainant while supporting the order passed by the High Court, submitted that the assertions made in the charge sheet on the basis of the material collected by the police do constitute cognizable offences, and as such the High Court was justified in dismissing the petition. Before examining the rival contentions we may briefly refer to some of the relevant provisions in the code. Chapter 14th of the code, containing sections 190 to 199, deals with the statutory conditions requisite for initiation of criminal proceedings and as to the powers of cognizance of a magistrate. Subsection within bracket 1 of section 190 of the code empowers a magistrate to take cognizance of an offence in the manner laid down therein. It provides that a magistrate may take cognizance of an offence either within bracket A upon receiving a complaint of facts which constitute such offence, or within bracket B upon a police report of such facts, or within bracket C upon information received from any person other than a police officer. Now I am going to dictate the third dictation on legal matter at the speed of 100 word per minute. Please note down. Ready? Start. Chapter 15th, containing sections 200 to 203, deals with double inverted comma complaints to magistrates double inverted comma close, and lays down the procedure which is required to be followed by the magistrate taking cognizance of an offence on complaint. Similarly, chapter 16th deals with double inverted comma commencement of proceedings before magistrates double inverted comma close. Since admittedly in the present case the magistrate has taken cognizance of the complaint in terms of section 190 of the code, we shall confine our discussion only to the said provision. We may, however, note that on receipt of a complaint, the magistrate has more than one course open to him to determine the procedure and the manner to be adopted for taking cognizance of the offence. One of the courses open to the magistrate is that instead of exercising his discretion and taking cognizance of a cognizable offence and following the procedure laid down under section 200 or section 202 of the code, he may order an investigation to be made by the police under section 156 within bracket 3 of the code, which the learned magistrate did in the instant case. When such an order is made, the police is obliged to investigate the case and submit a report under section 173 within bracket 2 of the code. On receiving the police report, if the magistrate is satisfied that on the facts discovered or unearthed by the police there is sufficient material for him to take cognizance of the offence, he may take cognizance of the offence under section 190 within bracket 1 within bracket B of the code and issue process straightway to the accused. However, section 190 within bracket 1 within bracket B of the code does not lay down that a magistrate can take cognizance of an offence only if the investigating officer gives an opinion that the investigation makes out a case against the accused. Undoubtedly, the magistrate can ignore the conclusions arrived at by the investigating officer. Thus, it is trite that the magistrate is not bound by the opinion of the investigating officer and he is competent to exercise his discretion in this behalf irrespective of the view expressed by the police in their report, and decide whether an offence has been made out or not. This is because the purpose of the police report under section 173 within bracket 2 of the code, which will contain the facts discovered or unearthed by the police as well as the conclusion drawn by the police therefrom, is primarily to enable the magistrate to satisfy himself whether, on the basis of the report and the material referred therein, a case for cognizance is made out or not. The next incidental question is as to what is meant by expression double inverted comma taking cognizance of an offence by a magistrate within the contemplation of section 190 of the code. The expression single inverted comma cognizance single inverted comma close is not defined in the code but is a word of indefinite import. As observed by this court in Ajit Kumar Palit versus State of West Bengal, AIR 1963 SC 765, the word single inverted comma cognizance has no esoteric or mystic significance in criminal law or procedure. It merely means to become aware of. Now I am going to dictate the next dictation on legal matter, again at the speed of 100 words per minute. Please note down. Ready? Start. It is clear that being an expression of indefinite import, it is neither practicable nor desirable to precisely define as to what is meant by single inverted comma taking cognizance single inverted comma close. Whether the magistrate has or has not taken cognizance of the offence will depend upon the circumstances of the particular case, including the mode in which the case is sought to be instituted and the nature of the preliminary action. Nevertheless, it is well settled that before a magistrate can be said to have taken cognizance of an offence, it is imperative that he must have taken notice of the accusations and applied his mind to the allegations made in the complaint or in the police report or the information received from a source other than a police report as the case may be and the material filed therewith. It needs little emphasis that it is only when the magistrate applies his mind and is satisfied that the allegations, if proved, would constitute an offence and decides to initiate proceedings against the alleged offender, that it can be positively stated that he has taken cognizance of the offence. Cognizance is in regard to the offence and not the offender. Adverting to the facts on hand, as noted above, on presentation of the complaint by the complainant before the magistrate on 15th September 2005, on its perusal, instead of taking cognizance of the offence alleged with a view to issue a process, the learned magistrate considered it appropriate to send the complaint to the police for investigation under section 156 within bracket 3 of the code. Therefore, it cannot be said that at the initial stage of 15th September 2005, the magistrate had taken cognizance. Thereafter, pursuant to the directions by the magistrate, the police registered the FIR on 22nd September 2005 and submitted its report. It appears from the afore extracted report that the stand of the complainant that A report regarding misplacing of the check and its user by the appellant had been lodged with the police was found to be incorrect. Nevertheless, after further investigations, the police finally filed the charge sheet against the appellant on 16th December 2005. Applicant Virendra Singh Chauhan on 22/9/2005, wide order of Learned Court under section 156 within bracket 3 CRPC, filed a report that accused block number 3 after getting the check somehow issued by applicant which got misplaced by witness Salim Ali by his own accord filled hefty amount of rupees 8,65,000 and produced it before the bank for the withdrawal of the same but did not get the money as cash was not there. This case after recording statement case was investigated and till now after investigation against the accused under section 420, 467, 468, 471 IPC is proved. There is stay arrested against accused from High Court of Nainital. Hence it is prayed that accused be summoned and after taking evidence he be punished. Although the order passed by the magistrate taking cognizance is not before us, but it is stated that the magistrate took cognizance of the aforenoted offences. Now I am going to dictate last dictation of the day. It will be at the speed of 100 words per minute. Please note down. Ready? Start. Learned counsel appearing for the state placed on record copies of the statements. It is pertinent to note that in the impugned order extracted above, the High Court has itself observed that no material had been placed before it, which in fact led the learned judge to assume that the prosecution has produced evidence in support of the complaint. It is thus manifest that in the absence of material stated to have been filed along with the charge sheet, the High Court did not get an opportunity to apply its mind as to whether, on the basis of the material before the magistrate, a prima facie case had been made out against the accused appellant. Under these circumstances, we feel that it may not be proper to express any opinion on the merits of the case against the appellant based on the documents placed before us by learned counsel for the state, save and except noting that the check in question, that is the single inverted comma valuable is security, single inverted comma close, does not form part of this set of documents. So far as the scope and ambit of the powers of the High Court under section 482 of the Code is concerned, the same has been enunciated and reiterated by this court in a catena of decisions and illustrative circumstances under which the High Court can exercise jurisdiction in questioning proceedings have been enumerated. However, for the sake of brevity, we do not propose to make reference to the decisions on the point. It would suffice to state that though the powers possessed by the High Court under the said provision are very wide, but these should be exercised in appropriate cases. Ex debito justitiae to do real and substantial justice for the administration of which alone the courts exist. The inherent powers possessed by the High Court are to be exercised very carefully and with great caution, so that a legitimate prosecution is not stifled. Nevertheless, where the High Court is convinced that the allegations made in the first information report are the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused, or where the allegations made in the FIR or the complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused, the powers of the High Court under the said provision should be exercised. Bearing in mind the above legal position, we are convinced that the High Court was not justified in dismissing the petition on the aforestated ground. In our opinion, in order to arrive at a conclusion whether or not the appellant had made out a case for quashing of the charge sheet against him, the High Court ought to have taken into consideration the material which was placed before the magistrate. For dismissal of petition, the High Court had to record a finding. Okay, this was the last one, and hope you might have written them very well. I will again dictate 4-5 matters tomorrow in the night at about 10 p.m. So please join me again. Thank you. Good night.